where the gentleman you had raised this thing, where there are what is defined as information. Now there are many issues here, but I would like to highlight three to start with. One is that there is a belief that you cannot ask queries under the RTI Act. So a lot of commissions and a lot of public authorities reject RTI applications which say, please tell us whether it was true that such and such thing happened before such and such thing happened. And they said it's a query, you can't ask for query. And I would respectfully submit that this is something that we need to discuss, because I think there's enough evidence in the Act to believe that this can happen. The second is that there's also a belief that you cannot ask yes and no types of questions. You cannot ask the public authority to say, is this true or not true, where the answer is in yes or no. And many information commissions have taken that view. This needs to be discussed. And the third thing which I want to flag, though it might not need to be discussed so much in detail, is that there is still a lack of awareness both about the implications of 2S as it refers to the private sector. Because as the law is today, people think it only applies to the government and to other public authorities. But actually 2F makes it a much more powerful act, because what it says is that any citizen can access any information from any private body that the government can access under any other law. What has happened is, A, the awareness of this has been weak, but B, the procedures have not been laid down, in the sense that I do not know of a single state or even of the center which has laid down the procedures about how you go around doing this. Do you apply to that ministry? Do you apply to do, what do you say? Some thinking also has to be done, and I think it has to be done by information commissions, on whether this is applicable across the board. For example, there is an Income Tax Act. Under the Income Tax Act, the Income Tax Department can access various bits of information from a private company. Now, is all that power then available to the citizen? Or is only that power which is unconditional available to the citizen? I mean, suppose, for example, the Act says that if you think that there has been wrongdoing, then you can access such information. Does the citizen have the right to exercise that power also? Or only that which gives a blanket power? So there are issues like this which unfortunately have not been worked out in any great detail, and 5 years, more than 5 years have passed. And I feel that there is a certain sense of jubilation in the private sector which I don't like, that we are out of the purview of this. And in this day and age, and especially if you've seen what is happening, I mean, yesterday, for example, all the bankers or therefore were arrested and things like that. I think there is a very great need for us to actively expand this to that. Then the next one is, now I'm moving out of the law, and this is the second part of it, which I'll quickly flag, and we might discuss it in the next session. Denials of information or rejections of appeal on bases which are strictly not within the RTI Act, but which are very prevalent. The first one is denied due to files lost or missing. This is very common. And in fact, I know some departments or ministries who made it a habit of saying that the file cannot be traced. And then therefore the information is denied. And I think this needs a detailed discussion, because I think legally there are other alternatives, and I'm not sure whether you can just outright deny it. Second is case dismissed instead of transfer under section 6(3). This happens very often. In fact, the High Court rules, unfortunately, in many states have sanctified this by saying that they will not transfer under 6(3), but even a lot of public authorities don't. But there's also problems with this. I mean, suppose I go to a small village panchayat and file an application asking for information about some other state which is on the other side of the country. How does that poor sarpanch with the PIO know who do I send this to? So we have to discuss what would be a reasonable ground on which you can say, okay, they didn't transfer it, there was a reasonable ground, and I think this needs to be discussed. Then one of the most misused clauses, at least at the CIC, if I might say so, is 7(9). 7(9) is this, that where you feel that there's disproportionate work involved. And the term voluminous information therefore gets used from time to time, that this is too voluminous, without any information commission, as far as I know, defining voluminous, saying okay, up to 100 pages you can get, but 101 makes it voluminous. or linking it up with the abilities of the department, etc., etc. So, but this is used extensively to deny information. I think we need to discuss this. And finally, denied just because, well, I've already mentioned this, just because it involves a third party without giving a hearing to a third party. I already mentioned this, the third party thing and stuff. So this is the menu that we had thought out on the basis of the data that we had available with us. Unfortunately, Arvind got delayed, otherwise he would have supplemented the basis to this. Now, my suggestion is that instead of debating this menu, first let's get on with this discussion. I think everybody will agree that these are important things. I'm sure there are other people who feel there are also other important clauses. We'll come to those. Let's start with these. So, Mr. Chairman, with your permission, I think you can open it first of all on the 8.1e, which is the fiduciary. And let's start having a discussion.
Yeah. 8.1e.
Can I suggest that Shailesh, who's done a lot of thinking on this recently, would you like to initiate it by putting across the issues, and then that might provoke other people?
In interpreting most of the provisions of the Act, I think, because it's a question also of how do you approach the whole Act of RTI. I approach it in this fashion, that lack of transparency has really, because there is a social context for all laws as you interpret. Interpretation is not merely interpreting words of an act, but there is a complete context in which you do this. My own context is that I believe transparency overall will do far more good to India at this stage than opacity. I mean, that's the fundamental premise with which I approach the law. I don't deny that. There is a bias, if you may call it, towards transparency. Given that, therefore, I take most of the provisions of 8.1 very selectively, but there are other things where maybe I would be doing things which may not find approval from a lot of civil society organizations. As far as the fiduciary part is concerned, I define fiduciary saying there is no perfect definition, and I refuse to even go by what is called dictionary meanings, because various dictionaries will have a variety of definitions for words. The way I treat fiduciary is, what is the traditional method of saying which is a fiduciary relationship? The traditional lawyer-client relationship, chartered accountant-client relationship, or doctor-patient relationships are what we have held as fiduciary. Now, what are the elements in these relationships because of which we call these fiduciary relationships? One, primarily there is an issue of trust. You trust that person. You will not go to a doctor if you don't trust a doctor. If you have, and the other thing which I also look at in all these relationships is that you have a choice of who you can go to. When I go to a doctor, I have a choice of selecting my doctor. When I go